Well, hi there, and thank you for attending today. I'm David Allen, as Gemma just said. Although I'm the Executive Director for Seeker Southern, this event is open to all Seeker regions, so welcome to you all. This is just one part of the Seeker training and development offer for our membership, and the topic today is a particularly important one, so I'm pleased that you could come along to this. It looks at the powers of the HSE, the different types of enforcement action they can take, and some of the key considerations as to whether to appeal the enforcement action. And it hopefully will provide a useful guide in setting out what key things you should consider if the HSE do issue an enforcement action. Your speaker today will be Matthew Bakewell, a partner and head of health and safety and commercial solutions at DAC Beechcroft LLP. DAC Beechcroft have already provided Seeker with training and development support this year, and I'm sure that you'll find this webinar as informative as their previous ones. You'll be able to ask questions in the chat function, as mentioned by Gemma, during the event, and this will be collated, and Matthew will look to answer some of these at the end of the presentation, where he's able to do that. I will now hand you over to Matthew, as I say, to deliver the webinar. So Matthew, over to you.
Thank you, David, for that introduction, and hopefully everyone can hear and see me okay as well. I just wanted to, first of all, give you a bit of a flavour about DAC Beechcroft first, and a bit about me, just so you understand where I'm coming from. So DAC Beechcroft, as you may or may not know, is a global international law firm, and we've got offices all over the UK. And indeed, within the UK, we have offices in the locations on the slides. We take pride in this because it means that in terms of our health and safety team, we are very accessible to a number of areas and regions locally. So we're able to provide not only international support, but also local support within the UK as well. In terms of me, I'm a partner and head of health and safety commercial solutions at DAC Beechcroft. I also sit on the IOSH Consultancy Group Committee, an international committee, and I sit on the Housing Quality Network Safety Network Advisory Committee as well. And in terms of my experience, I'm a criminal lawyer by background, dealing with criminal cases involving accidents in the workplace, and other such like issues of a regulatory nature where there is a prosecution. I'm not a civil lawyer. I don't deal with personal injury claims, and never have done. So my role is, in effect, when something has gone wrong on site, is helping with the investigation, helping deal with the HSE, the police, the fire authority, the local authority, whichever enforcing authority is the correct one. And then helping clients with their investigation reports to make sure there's legal privilege on them, and then dealing with any consequent prosecution or inquest in the event of a fatality. And our team nationally is involved in a significant number of high-profile cases, and indeed nearly all of our teams across the UK have just been rated Tier 1 within the Legal 500. So on top of that, we have a very strong health and safety team. And what I want to do today is share some of the experiences that our team have had with you in terms of enforcement action, some developments within the law, tactical considerations as to why you may want to consider, if you are served with enforcement action, what to do. And I think that's really important because a lot of the time what we tend to find is that site supervisors are on site, site managers are on site, they may get an unannounced visit by the HSE, or it might be following an incident. And the pressure of having the HSE arrive can be quite a lot for some people to cope with, especially if there's been an incident. And traditionally what we found is that site managers, site supervisors, for example, are served with enforcement action without really understanding what it is. And because there's been some sort of discussion leading to it, they're not always entirely sure what to do, and it ends up with some sort of enforcement action being taken by the regulator. Today we'll focus on the HSE, and that can sometimes cause problems further down the line. But in its own right, we want to consider what the impact of all of this is. So I'm going to talk to you for about 30 more minutes or so, maybe a touch longer. And the issues I'd like to cover are this. When are we likely to face enforcement action? And thereafter, what are the powers of the HSE? Where are they getting these powers from? What types of enforcement action they are and the requirements for each one, how to appeal it, and then some tactical considerations. I'm going to share with you a couple of case examples as well in the construction sector that we've successfully appealed improvement notices, and then finish off with some concluding remarks. And then if there are any questions, I'll endeavour to deal with those at the end, if I may. So please do feel free to put any questions in the side panel, as has been explained, and I'll deal with those at the end, if I may. So when might we face enforcement action? Well, in reality, the answer is at any time. The HSE can can undertake unannounced inspections. They can undertake announced inspections, all part of their compliance functions, so i.e. to inspect to make sure that organisations are complying with the relevant regulations and legislation and have the correct systems in place at the time. And what we have tended to find is that with these unannounced inspections, is that because they're unannounced, people tend to be a little bit unprepared on site and can have a little bit of a panic. With the announced inspections, it's a lot easier because obviously you know they're coming. Incidents on sites, including accidents and near misses. We've got a number of cases at the moment where there's been a near miss. It's been reported because it fit the RIDDOR requirements for whatever reason, specific to that particular case. And the HSE have taken a very strict approach and investigated it on the basis that it could have resulted in someone being very seriously injured, if not killed. And actually, we're finding the HSE are becoming quite more interested in near misses and establishing what the actual risk posed was, even if that risk didn't eventuate. And for those of you that are well versed in health and safety law, you will appreciate that the HSE only need to work on the presence of a material risk. It is down for the duty holder, i.e. you, to make sure that you've taken all reasonably practicable steps to mitigate that risk. So what have you done to basically eliminate it or reduce it? Just because someone may not have been killed or injured, it doesn't necessarily mean the HSE won't enforce, and it certainly won't mean they won't prosecute. And I think we had 2 clients last year where there was following unannounced inspections, following public concerns, a point I'll come on into a moment. Clients were prosecuted under health and safety legislation because of concerns the HSE had about the presence of risk, despite the fact there was no accident. Public concerns, we're seeing this more and more. We're seeing a lot more members of the public raising concerns with the HSE in terms of unsafe working practices. I have just been concluding a matter for a client, a construction client, where members of the public complained to the HSE about some work that one of our contractors was doing. And we had to build a fairly robust case fairly quickly to avoid any enforcement action. Indeed, we were successful in that. But we are seeing a lot more of the public. Everyone's got a mobile phone, a lot of those are smartphones. A lot of people are very quick to take a photo and put it on social media, and some of those are quick to put it on forward it onto the HSE as well. I think that is becoming more and more of a problem, if I'm honest, in terms of how the HSE become aware of incidents or potential dangerous working on site. And of course, at the moment, we are doing this virtually because of the pandemic. And as a result of that, the HSE brought in their public call line, their public telephone line, and I'm sure that some of you have already been faced with either disgruntled employees or disgruntled members of the public or contractors calling that line complaining about COVID precautions that are in place. And I think we will see a lot more of that. So that is where the sort of circumstances that may result in enforcement action. Before we look at the particular types, I just want to touch on the powers of the HSE, because I think one thing that people sometimes forget is that the HSE powers do have limitations. And consequently, it's important that we understand just exactly what they can do and what they can't do. Because we don't really want to be in a position where we're having to, for example, claw back original documents or have difficult discussions with the HSE about how they undertook their investigation. But also, I think sometimes that bit of knowledge in advance, that bit of understanding, actually provides a bit more confidence for the people on the ground. So I do quite a lot of training sessions with site supervisors and site managers about HSE powers, what to do if it goes wrong, what to do if an inspector calls, because it's really important that they've got that confidence there. But ultimately, that is the foundation in which Section 20, of course, that people have the power to do. The HSE have the power to do what they want to do in terms of enforcement or other such powers. So the powers of the inspectors are contained within Section 20 of the Health and Safety at Work Act. And we're going to consider some of these powers over the next few slides. And paragraph E is one that I think is always of some interest. And as you can see, it says, as regards any premises he has power to enter, direct those premises or part of them are left undisturbed. And this is a power that we see generally following any accident where, for example, there's something going on site, or there's something that's gone wrong, and the HSE wants some time to be able to get to site or get a specialist inspector to site or an expert to site. And they say that you can't move anything, you can't touch anything, it has to be left undisturbed. This is not an open-ended power, and if an inspector seeks to rely on this power, we would say that discussions should take place as to how long the section is being relied on, because it must be there for a reasonable time to allow examination or investigation. It's not just simply putting the tape up and not touching it for months on end because the HSE decide to do something else in the meantime. And I think it's really worth having a proper discussion if you do get to that position. And of course, it's not necessarily just after an incident. You know, if the HSE turn up and they see a bit of equipment that they're not very happy with, they could say, right, don't use that. We want our inspector to come and have a look at that tomorrow. In terms of Section F, it states to take measurements, photographs, and make such recordings as they consider necessary for the purposes of examination or investigation. And I think that, again, is pretty important, because we have seen, unfortunately, traditionally, HSE not always very good at taking the right photographs or good quality photographs or good quality measurements. And ultimately, if they do serve enforcement action at a later stage, they may rely on, for example, those photographs or those measurements. So I would always encourage people to take their own, to make sure that the photographs are clear, people understand what the photograph is showing. You know, a picture says 1,000 words, but it's important those words have meaning and people understand what the words are. And I think it's always really important that you are taking your own evidence as well. So anything that HSE photograph, do the same, because in reality, you may rely on that at a later stage if you're going to challenge anything the HSE are doing. Moving on to the next slide, in terms of the powers that the HSE have. Power H is often used just to seize equipment for inspection, such as machines. I think what we're seeing a lot of at the moment actually is HSE and the police going out on site and inspecting it on site unless there's a reason to take it away. As we are speaking now, I have got the police poring over a vehicle that was involved in a fatal incident not that long ago, and they are determining whether or not there's any defects in it. The HSE used to send everything to Buxton, because that's where the HSL labs were, but now they don't always do that, and particularly in the construction sector, if it's a big bit of kit that you can't really move or is difficult to move, they do tend to send inspectors out to go and have a look at it. And that's quite important, of course, because if they're looking at whether a machine has a defect or has failed in some way or is unsafe, you may want to get your own experts as well, so that if enforcement action is served, you're also collating sufficient evidence to consider whether or not you think that is a fair opinion. And we'll come on to that point about opinion in a few moments, because that is incredibly important. Power J, I think, is one of the ones that often gets overlooked. It's what we call the Section 20 witness statement, where it compels an individual to answer questions and provide any relevant information. There's lots of caveats. I would say that if you get to the point where you're getting into Section 20 territory for statements and witnesses giving Section 20 witness statements, I would suggest getting some legal advice straight away before going into that, and indeed that person is entitled to get it. And that's, I think, one of the nuances, is when the HSE say, well, we just want to take a statement. I think it's important we understand what type of statement they're taking and why. Very few people will push back and say, okay, we're more than happy for you to speak with our people, but on what basis? Are you taking a Section 9, i.e. a voluntary statement, or are you taking a Section 20, which is a compelled statement? Just so that you understand on what basis they're getting that information and why they're doing it, so that you can make sure the right support is there for those individuals. Because ultimately, enforcement action, if you're challenging it, the evidence will often be based around what people say and what people don't say, i.e. what's in their statement. Power K is the power to require the production of and inspect and take copies of any entry in any book. And this is absolutely crucial, because they are only entitled to copies. So it is vital that we don't have HSE inspectors wandering off with our construction phase plans or our original risk assessments and method statements, especially the signed versions, because it'll just get lost, to be honest. So it's really important that our people understand that anything that the HSE are asking for in terms of documentation, they're only entitled to copies. And I think the one thing that I've seen in particular that the HSE have really struggled with is electronic systems. A lot of construction sites are moving away from having lots of paper on site and having stuff on computers or iPads or whatever, and some sites doing learning or inductions in advance of people even going on site. But it's really important that our people understand what documents we have. So if the HSE are asking for a copy, if that is electronic, our people are not thinking, well, we've not got a paper version of that, so I've not got it to give the HSE, because that can actually sometimes result in enforcement action being undertaken because of a misunderstanding of what is actually being asked for and on what basis. And one of the case examples I'll give you later is a good example of how that happened. I've forgotten how to move on. There we are. And then finally, and it's a bit of a technical point, so I'm not going to dwell on it too much, but in reality, I think one of the things we have to note and have to accept is that Section 20 does give the HSE, in reality, far more power than your average police officer. Because if you think about it, if you're on a night out and you witness a fight or a car accident, you're not compelled to provide the police, with a witness statement of what you've seen, whereas the HSE actually do have that power. The one thing that I would say, and the HSE, if I put my cynical lawyer's hat on, do tend to overlook this a little bit, is power MAs or qualification MAs, I think. And that is where if legal privilege is in place, then those documents can be withheld. Now, that won't apply to any documents that have already been created, but if, for example, your enforcement action is off the back of an investigation because of an accident on site, then if you have engaged lawyers to assist you with the accident investigation and the report is privileged and any information taken from witnesses is privileged, then you're not obliged to serve that on the HSE if they ask for it, even under Section 20. So I always think it's really important to set out the powers of the HSE first, because actually I think sometimes we just tend to plod on and accept what the HSE is saying. You tend to find, certainly the boots on the ground, a lot of people are reluctant to push back on the HSE, but there's no reason why you can't. Obviously, it needs to be done in a sensitive way and a correct way, but I think it's really important that we are setting this presentation, if you like, on the basis of what those powers are and how they can be exercised and why they're relevant. I have seen a question, and given that there's just the one and it relates to this section from Simon, can they take pictures of people? I think the answer is twofold, really. If people are within the picture, then yes, they can, because if someone is, for example, taking a photograph of some unsafe work or someone who's working at height in an unsafe way, that's the evidence that they're taking. They're taking a photograph of someone working unsafely, which may prompt them to then go with it to take enforcement action. Whether or not at a later stage people's faces need to be blurred out for whatever GDPR reasons are necessary is a matter for the individuals involved, but there are a number of exceptions within data protection where the evidence is taken, or a photograph is taken, or image is taken in relation to a criminal matter. So the three key areas of enforcement action, really, apart from obviously a criminal prosecution, are improvement notices and prohibition notices. I've already touched on the notice to leave undisturbed. I don't propose to revisit that in any huge amount of detail going forward. So let's just consider an improvement notice first. An improvement notice is issued to prevent and or stop unsafe workplace activities where the inspector is of the opinion that there is a contravention of the law and it is likely that the contravention will continue or be repeated. Okay. The improvement notice will set out what you're doing or not doing that puts you in breach of health and safety law, state what needs to be done to correct the breach and why, and specify the time you have, which is at least 21 days, to comply with the requirements of the notice. And you have 21 days to appeal. The effect of appealing an improvement notice is that it is suspended and it has no effect until the determination of the appeal. And we'll talk about the tactical considerations there. But I think it's really important to draw out some key issues there in terms of an improvement notice. First of all, it has to be there to prevent and or stop unsafe workplace activities. And I think that's really important, because an improvement notice is not just there because something's not quite as you would like it to be or as the HSE inspector would like it to be. It's not because, or it shouldn't be used to just change something for a format style. There has to be, in reality, something that is inherently unsafe with what is going on that requires a formal notice from the HSE for you to make improvements. Second of all, in terms of the important bits for its issue, is whether that contravention will continue or be repeated. So if, for example, measures have been taken that stop that potential breach already, it's important that we challenge an improvement notice before the inspector even tries to issue it, and turn around and say, well, that risk is no longer present. It may well have been at the time, but we've done this to stop it, and this is why it won't be repeated. And sometimes organisations are too quick to accept an improvement notice because they know they've already made the improvements, rather than saying, well, hang on a moment, that risk isn't there anymore, so we don't actually need it anymore. And that, in my view, is the way to carefully manage the HSE, though I appreciate there may be other factors that come in that cause some concern. I'm going to talk about the issue of opinion later on, but I will flag that the notice is in relation to the opinion of the inspector, and I can't stress that word enough, but I will come on to that slightly later on. In terms of a prohibition notice then, those are issued to prevent and or stop unsafe work activities, where again the inspector is of the opinion that there is a risk of serious personal injury. Notices can be deferred for a specified time, or they may take immediate effect if the risk is imminent. Now, we tend to see prohibition notices issued on generally equipment that's failed or dangerous equipment, or on work processes where something is so dangerous in the opinion of the inspector that they issue a prohibition notice stopping everything. These are a bit of a headache because even if you appeal them, they still have effect. You would have to try and get some sort of injunction to say why the prohibition notice shouldn't be in force in order to try and get rid of it in the interim until any appeal was heard. But in reality, you would want to try and get your appeal, if you are appealing it, listed as quickly as possible, or work with the HSE to try and deal with the issue within the prohibition notice as quickly as possible. Out of the two, prohibition notices are far more restrictive. I think the name probably gives it away, but we have seen cases where the content of a prohibition notice makes it very difficult for operations to take place and can sometimes pose other health and safety risks. So I'd always suggest that if an inspector has intimated to any of our site managers or any of our people on the ground that they may be considering a prohibition notice, that a real sensible discussion is undertaken as to why the HSE are thinking about that, what we could do to try and remedy that issue straight away to try and avoid the prohibition notice being served, because at least with an improvement notice, if you appeal it straight away, it's suspended and you can carry on as normal within reason. But the prohibition notice, you don't have that flexibility. So I'd always be wanting to really encourage a discussion at that point. In terms of appeal, there is a time limit, so 21 days. Rather weirdly, when you appeal enforcement action, you appeal to the Employment Tribunal. And that in itself causes a little bit of a headache because the Employment Tribunal works on the civil procedure rules. And obviously, if there's been an accident and a potential HSE investigation, that's under the criminal procedure rules, the criminal justice system. And one of the issues that may occur is if you're trying to challenge or appeal an improvement notice or prohibition notice following an accident, is ultimately what you don't really want to do is get to the point where any potential trial that you might have from a criminal point of view, if you're prosecuted by the HSE, is inadvertently heard by the Employment Tribunal because you're also challenging any enforcement action. Clearly, with a prohibition notice, if you need to get a site back up and running, your hands may be a little bit tied. But with an improvement notice, I've got a number of improvement notices at the moment which have been adjourned off. We appealed them within hours of getting them. And they've been, in one instance, appealed now for the best part of 4.5 years, coming up to 5 years, because there is an ongoing criminal case, and we don't want the outcome of the enforcement action appeal to impact upon any criminal case. I said I'd touch on it, but this is the bit where I think a lot of people lack the confidence to challenge the HSE. And the reality is this, is that when you are issued with an improvement notice or a prohibition notice, you are issued it on the basis that the inspector at the time formed the opinion that there was something wrong. And I think that's really important, because opinion is based on often two things really: competency and what is being seen. And you tend to find that most inspectors may not have a background in construction, and those that do, it may have been some time ago where things have since changed. And so it really is that your people may genuinely take the opinion that the opinion of the inspector is wrong, that the inspector is just simply wrong. And I think that's really important, because it is their opinion that you are challenging. And it may well be that a more experienced or more qualified inspector who had attended might form a different view completely. And that's the slight quirk again with him challenging enforcement action, is that actually what you get is in the proceedings, it's the name of the inspector. So you actually challenge the inspector. You don't challenge the HSE. It's the name of the inspector versus the name of your organisation in proceedings. So I think that's absolutely critical. And that's the other point, the second point. So first point, competency. Second point, what they've seen. I think it's really important that when inspectors are on site and asking questions, asking for documents, etc., people on the site really understand that they need to try and make sure that the inspector is of the view that there is no breach. And if they think there is a document or think there is something that can help, trying to not necessarily volunteer that, but making sure that the inspector is not left with the impression that there's nothing there. So that comes back to this point where a lot of electronic systems, there might be a lot of documentation, there might be risk assessments, method statements. It's really important that the HSE are being given not unfettered access or unlimited access by any stretch of the imagination, but are being given the impression excuse me, that there are systems in place, there are processes in place, and there is documentation in place, and that can be provided. And I think one of the things that I've seen from site managers in particular is they're not asking themselves at the time, when the improvement notice, for example, may have been served, is did the inspector have everything or ask for everything that they needed at the time to properly form their view? Are they being given the full picture? It's no good them serving a improvement notice around work at height, for example, if there's a massive section of documentation on the system that may have crashed on the particular day the HSE weren't there and no one thought to mention it. I think you can certainly try and make sure the HSE are trying to actively not serve improvement action if you can. The law changed in favour of people who wanted to challenge enforcement action in the case of Chevron. Again, a really important case, really, because as you can see here, the improvement or prohibition notice is entitled to take into account material that was not available to the inspector at the time the notice was issued. And I think that's really important, because if, for example, the construction phase plan should always be on site, but let's say there is a system crash, or let's just say that there is information that is relevant and important, and maybe it's not been realized at the time, it can be provided at a later stage. And actually, the two cases I've had recently where we have appealed improvement notices have been successful, i.e. the HSE have withdrawn the improvement notices before we've even had to go for a full hearing, because we have provided them with information that really they should have asked for, they didn't ask for. We then provided it to them, and then they accepted that had they been provided with that material at the time, there would have been no breach. And because that material was already in existence, there was no breach, so the improvement notice could be withdrawn. And I think that's quite an interesting approach and very helpful law, especially because previously it was incredibly unhelpful. Some tactical considerations, and we've already talked about improvement notice appeals having the effect of suspending the notice. It's now free to appeal an improvement notice or prohibition notice. There's no cost at court. Obviously, there's legal fees, and in reality, these type of cases, each side bears its own costs. So even if the HSE incur costs, they would generally have to pay it for themselves. It's not something they can add on the FFI open-ended invoice list, as we tend to see it. I think there's also important to realise that there is a register of enforcement notices that's available to the public, and that can also be used by employees and unions. But of course, in a lot of tender opportunities, there are questions around improvement notices or other enforcement action that may have been taken by the HSE, and that might have a direct impact. So it may well be that if you are of the opinion that the inspector's opinion is incorrect, and you can evidence that, then I would always encourage you to consider appealing the improvement notice. And in reality, as the case moves on, if you think that your appeal is no longer in either your interests or is as important as it was from the outset, then you can always withdraw your appeal. But as long as it was made in good faith at the beginning, I don't see any issue with that. Sometimes we require time to maybe get experts involved and have a think about, is this something that we want to appeal? If so, on what basis? What's going to be the impact if we accept this improvement notice? Does that mean we have to make changes across the whole organisation, or is it just a local issue? Is this going to incur a disproportionate amount of costs for the organisation if we accept this? And is it ultimately going to damage our reputation if we accept this, when we are very safety conscious and we don't actually think that this improvement notice or prohibition notice was issued properly? And I think it's really important that if you've got an improvement notice that's been issued on site, the site managers, site supervisors are confident enough to escalate that appropriately within the organisation, and there's a system and an easy system for them to follow in order to do that, so that a decision can be taken at a more senior level as to whether or not an appeal is required. Because with 21 days to bring an appeal, it does give us very little time in reality to have a real serious think about what was in place, what documentation was there, what that documentation says, whether it's suitable and sufficient, whether the processes are in place, whether those are suitable and sufficient. And if we want to instruct experts, consider that as well. If it's a standalone improvement notice, you may feel that that's a disproportionate approach, but it may well be that your improvement notice, as I mentioned earlier, runs alongside active investigation or incident, and it may well be that actually the tactical consideration of appealing an improvement notice is so that you don't feel that you're tying your hands for any potential prosecution. And for those of you that are aware of the sentencing guidelines, you will be aware that if you are convicted, i.e. plead guilty or are convicted after a trial of health and safety offences, organisations can be fined huge amounts of money. So it may well be that appealing an improvement notice, for example, is actually a larger strategy for defending a wider case. I just wanted to take you through a couple of examples of cases that I've got on a sort of Chatham House rules basis, though I appreciate this is being recorded as well, where I advised on a couple of clients in relation to issues. The first one was a HC served an improvement notice regarding people around vehicles and safe driving routes. And this was actually in relation to a bin lorry refuse collection vehicle that was surrounded by cameras and all sorts of other issues. And one of the issues that we had to think about once the improvement notice was served is, well, what did we have in place at the time? And when we looked at everything that we had in place at the time about how we trained people around the movements around vehicles, the routes that were planned, how those routes were planned, the technology that was inside the drivers' cabs, all that information that was available, we took the view that actually the HSE hadn't really taken into consideration what was in place. And what they were asking us to improve wasn't particularly clear, because if you took everything holistically, we said, well, what more is there? You know, there's every system in the world is reliant on a human operating it, and no matter how many systems you put in place and how many safeguards you put in place, there's always a potential for an element of human error. Not a popular argument with the HSE generally, but if they're unable to advocate what exactly the improvements look like that would satisfy an improvement notice, then one wonders, well, what actually can we do to comply with this? Everything's there. What more? And we pose the question back on the HSE alongside the practicalities of actually trying to change anything, as well as them accepting that there had been some minor changes that were being made, i.e. the vehicles were being replaced with 360 cameras. So that was in place already. The HSE had to accept and did accept that actually there was no breach at the time, so they withdrew the improvement notice accordingly, because they just hadn't fully taken into consideration what was there, and in reality, what could be improved. You know, if they can't tell us how we can improve it to comply with their notice, although a lot of that is on us to demonstrate, there has to be something tangible the HSE would look at and say, fine, yes, you've complied with that, in my view anyway. The second case, more recent, and this is this horrendous bit of publication that we've seen, that the HSE, and when I say horrendous, in terms that the HSE seem to be taking it as legislation rather than guidance, and that's the 16 steps for fire safety that's within the Structural Timber Association guidance around timber frame homes. And what we've seen is the HSE almost saying, look, if you don't have a fire risk assessment that looks like and follows the format of the pro forma within the Structural Timber Association guidance, that you're somehow inadequate and not achieving compliance for fire safety on site. And we had a case where we argued, well, look, actually, this is not legislation; it is guidance. The pro forma is there to assist, but actually, what you need to take on board, HSE, is exactly what we have in place. You know, if all our other documentation has the effect of dealing with everything in the 16 steps, for example, then why do we need to follow their particular format? You know, you don't serve improvement notices, for example, just because people may not happen to follow the HSE pro forma for risk assessments that they've put on their website. You know, as long as you've got everything in there that makes you compliant, then in our opinion, so be it. And actually, after a number of quite long arguments, we got the 2 improvement notices in that case withdrawn by the HSE again, simply on the basis of saying, look, you know, let's take a sensible step back and look at this. And in reality, if you can get the HSE to withdraw any notices that they've done or in served, then it saves the litigation risk, if you like. And I think there's always a good argument to be had about having a without prejudice discussion, i.e. an off the record discussion with the HSE shortly after issuing your appeal, so you can try and see if there's any grounds for agreement and moving the case forward without prejudicing your position. in terms of COVID, very topical, I don't propose, I mean, everything I've said is relevant, whether it is for work at height, for making a site COVID secure, for, I don't know, people versus traffic management, which is still a major, major one, especially in the construction sector where you've got heavy vehicles moving around people. Walkways may be fluid in terms they may change on a regular basis to incorporate changes in the design or the build and stage of the work. And I think it's really important that everything I've said today is applied in a general sort of a broad brush approach across the construction sector. What I would say is that we are seeing a little bit of COVID enforcement here by using enforcement action. Rather embarrassingly, one of the government agencies in Leeds was subject to an improvement notice because it's not complied with social distancing and making the office space COVID secure. I'm sure there's anecdotal evidence of it happening within the construction sector. I'm pretty sure that the HSE are on top of it. They seem to be undertaking some inspections again now, or they were certainly before the lockdown. But what we are seeing in reality is that the impact of COVID in terms of making places COVID secure tends to be internal, i.e. office space, rather than external in terms of, you know, the build work, if you like. And that's in itself a little bit of a headache if you think about the way we've traditionally got buildings and construction sites operational on a daily basis. So things like daily safe start meetings, on-site welfare facilities with canteen areas, often porter cabins that may have one door and a fire door, so and limited space within inside that. Training rooms for things like induction, site inductions, even access and points can be sometimes bottlenecks if work is not staggered. And then on top of that, of course, you've got the usual hustle and bustle of the site office. So my assessment is that in reality, enforcement action is more likely to be for those pinch points, those areas where it's a little bit tricky to just get that distance in place, because in reality, you're going to be struggling simply with the space. So concluding remarks is that the impact of COVID on working practices and public opinion is differing. And I think this is really interesting, actually, because I have had two bits of advice I've had to do recently where clients have come to me and said, I've got an employee who just doesn't believe the science, thinks it's all a myth and government propaganda, and is refusing to wear a mask. What do I do? And then others coming to me saying, well, actually, I've got an employee who says they've got a medical exemption, but they won't tell me what the medical exemption is. And, you know, we've tried to tie different masks for them, for example. You know, obviously all of that leaves an organisation open to enforcement action if it's against their own policies or procedures or risk assessments. And, you know, ultimately we've had to say, well, the health and safety issue is resolved. The health and safety issue is the risk assessment has determined you must wear a face mask. Now it's an issue of employment rather than safety, and whether that person is prepared to risk their job over it. I think the other thing to bear in mind is that employees are being actively, as well as members of the public, being actively encouraged to report bad practices. I think that's become very obvious with this helpline that was all over the HSE posters that they published around COVID compliant buildings and COVID compliance generally. You know, do you think this is unsafe? Call us, basically, and a telephone number. So people are being actively encouraged to try and report bad practices and unsafe work. So making sure that if there are allegations made or that you're aware of something and documenting that and developing your own evidence is quite important. And likewise, if something does come out, making sure that you are, you know, doing something about it. You know, there's going to be a balancing act going forward, isn't there, between the tight on cash and work and trying to make sure it's done safely. You know, I'd always be careful about putting profit before safety, but in the end, the test is whether it is proportionate. So as long as you can argue that the measures you're taking are proportionate to the risk, then I think, broadly speaking, you'll be okay. Though each case is specific, and I wouldn't want to be leaving you with that overall just general impression that you don't have to invest in safety because it's not proportionate, because it's not this month's topic, for example. And then in the event of occupational exposure, for example, for COVID, then and there's likely to be a RID or an HSE investigation by the HSE and other regulators, and we're already seeing in reality the HSE beginning to use a lot of enforcement action around COVID, but actually a lot of enforcement action more broadly, because they're struggling to get out on site, and when they do get out on site, they issue the enforcement action, but actually a lot of it, could be in lieu of actual a real investigation or prosecution, because they're just so swamped with work at the moment, and they have really struggled to adapt to working from home because of their technology. It's very difficult to assess whether for 2020, 2021, the HSE's preferred method of enforcement will be improvement notices and prohibition notice rather than prosecutions. And we've already seen a dip in prosecutions anyway. Not that I wish to put in any complacency there, but I think that's just simply because of workloads, not necessarily, and a backlog, not necessarily because the HSE won't take further action going forward. But it may well be that there's a temporary plaster of enforcement action put in place. But we shouldn't obviously just take that at face value. I would always treat an enforcement action, whether it's improvement notice, prohibition notice, or even a notification of contravention under the fee for intervention scheme, as being the HSE saying that you've broken the law. And if you don't agree you've broken the law, don't accept it, think about it, and take an E and have a think. Most people, if they receive a speeding ticket but no information about where they were speeding, when they were speeding, or why the police have evidence that they were speeding, most people wouldn't pay the ticket. They'd say, why? And I think we often forget to do that in health and safety, especially around enforcement action. As usual, I've talked for quite some time. I apologise for that. I hope it has been helpful. I am going to go to the Q&A mode, Gemma. I think that's the right one to do. Is that right? Ah, yes. So I'm pleased you commented on the issue of reputational damage. A good HRA is gold dust in winning work. Site personnel need to be regularly reminded of this. Paul, I'd simply add to that, yes, but also funding. I know that a lot of house builders may rely on funding from various agencies or pots of fund, and demonstrating a good health and safety record is critical in that as well. So I'd always be very careful about, again, accepting improvement notice just because you think, it's more hassle to appeal it. It might be more hassle to get funding to carry on working and or win a tender going forward, trying to justify why you accepted an improvement notice you didn't think should have been issued in the first place in a tender pitch. What about historical HSE disgruntled ex-clients reporting to the HSE monthly after the event? How did the HSE generally approach this? Lewis or Louis, apologies, I'm not quite sure how to say your name. It varies, I think. I think ultimately it probably depends on how serious the allegation is and what evidence there is. If it's been some months or years after the event, it begs the question, well, where's the proof? Taking it out of health and safety law, for example, if someone says, you offended me, 7 years ago because you said something that was a bit, a bit nasty, and you say, well, what did I say? And they say, well, I can't really remember, but it was a bit like this. You think, well, no, not for me. And I think you'd probably have to take the same approach with this. The HSE may start an initial inquiry, but where it goes from there and how they can evidence it, I think is difficult. And I think the HSE would be loath to get too embroiled in all of that if it's more historical, especially if you can demonstrate, for example, that if there were issues that the HSE pick up on and you've taken improvement action since voluntarily and the issue is not there anymore, then they can't really issue an improvement notice for something that's been improved.
Yeah, thank you very much to Matthew and to the AC Beechcroft for another really interesting webinar. Thank you very much for your time.
My pleasure.
Everyone take care of yourselves in these uncertain times, and we hope to see you at another event very soon. Okay, thank you very much. Goodbye.